I'm going to call the study session to order and ask Chief Jones if you would lead us in the pledge of allegiance.
Join me in pledge of allegiance, please. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Where's Jeff? He's not here. Is Jeff on?
He is not.
Is Ryan on?
He is not.
Okay, well, it's a study session. Go ahead and start. I think we can.
Sure.
Miranda will probably have to take roll call again once it goes to reopen, once we convene the regular meeting.
Okay, so for now, Sandy Smith,
Present.
Scott Dorman,
Here.
Ryan Leahy. Absent, Jeff Robbins, absent, and John Smith.
Here.
All right, so I'm going to go ahead and start the study session, which is going to be a presentation on the open meetings. Law. First show. All right. Well, welcome to my tutorial on the Open Meetings Law and Open Records Act. I'm glad it's being recorded so that people who aren't here can have an opportunity to go back and take a look at it. I am going to try to. I don't know how to get rid of this. Okay, that's not. Oops, all right. All right, so the open meetings law can be found, start with that, in sorry, yeah. I can't see my own slides because of the Zoom. Ah, there we go. Okay, Colorado records, Colorado statutes in section 24-6-400 and 24-72-200 through 205. Those are the statutes where you will find both the open meetings law requirements as well as the Open Records Act requirements. The statutory framework is such that I'm just going to kind of go over it here briefly. That when a quorum of a board, or in our case, 3 or more members of a local body, that's us. We're not a state body, we're a local body, so different rules apply to state bodies and local bodies. State bodies, it's 2 or more. For local bodies, it's 3 or more. Is present or expected to be present, and the adoption of any policy, position, resolution, rule, regulation, or formal action occurs, or where public business is discussed, or during which formal action may be taken. By the way, this includes email exchanges and telephone calls and any other kind of communication format that you can imagine. Then you have to post a notice of that meeting and an agenda for that meeting on the website 24 hours in advance of that meeting. And then you have to take minutes and treat it just like a normal meeting. It has to be publicly recorded, and the minutes need to be available for public inspection. So I want to talk a little bit about what constitutes a meeting, because I think it's really important and people get confused about what that really means. Like, when can they talk to each other? Well, really, you can't. At least 3 of you can't. At least 3 of you can't if what you're going to discuss is anything that is public business. All right. And so the courts in Colorado have elaborated on some of this for us, because the statute doesn't really make it clear exactly what it means to discuss these things. So the definition in the statute is any kind of gathering convened to discuss public business in person, by telephone, electronically, including email, or by other means of communication. So what does it mean to discuss public meeting, business? All right. It means whether you are discussing the merits or the substance of any pending public business. Okay, so if the three of us were to walk outside this room and go down there, not call an executive session or anything else, but talk about anything that's a matter of public business that is or might be pending before this body, we can't do that. All right, we need to notice a meeting to do that. Now you may have noticed that from time to time, I will ask the board to create a committee of 2 people from the board to go do things and report back to the board. That's not a problem because obviously that's not a quorum. It's not 3 or more members. 2 members of the board can discuss things related to public business, i.e. they can discuss, as we have, what it is that we're going to bring to the board. They can discuss, in your case, you know, you can go interview, the 2 of you are on the subcommittee on the hiring of the potential chief. You need to be able to talk about, as between the 2 of you with the chief, okay, who are we gonna get proposals from, you know, who would we recommend to the board and why? But your job is to come back to the board and to recommend, to tell us what you did and to make your recommendation and to offer it for full and fulsome discussion in public. So while the 2 board members can discuss public business in those kinds of contexts, they can't make a decision. You can't make a decision. You can make you can decide on something you're gonna recommend to the full board, but it's for the full board to make that decision. It's a little tougher if you're a state body and two people can't do that. So there's always a subcommittee of 1 can do this. Now, sometimes they can do certain things, but I'm not gonna get into state bodies because they're different from local bodies. So social gatherings or chance gatherings, if you and I, Hippie, have decided we're gonna go to La Cocina de Mama and we're gonna talk about an item of business has nothing to do with fire department stuff. And Scott walks in and says, "Hey guys, how you doing? Can I join you?" That's perfectly okay, as long as we don't discuss anything related to the essence of pending public business when we're at that lunch. It's a chance encounter. The 3 of us are sitting there. Now, it might be a good idea for us, Hippie and I, to reject poor Scott and say, you know, probably it wouldn't look great for the 3 of us to be sitting here talking because, you know, it could create the appearance that we're doing the public business at the restaurant, and we're not. But that is to say that a chance gathering, a chance thing, and now if I wanted to invite all of you to dinner at my house, which by the way, I do intend to do at some point, I want to host a board dinner at the house. In fact, I'd like to do a series of dinners, maybe have a couple staff members come, a couple board members, and just make it a purely social gathering where people can kind of get to know each other. And, you know, I haven't really figured out how my schedule relates to these auspicious ideas that I have about hosting dinners, but those are social gatherings. And those are not included. Those are not something that we have to publicly notice. I don't have to feed everybody from the district who might want to show up at my house. You know, it's a social gathering and that's fine. Now, electronic gatherings, if you will, are emails. There are other types of communications that are electronic in nature, whether it's a Zoom call or whatever. But let's talk about emails for a second. I have a slide on it. I did. I think it might have gotten deleted. A couple of my slides got deleted, you guys, and I'm really sorry to say that, but no. So emails. You'll notice from time to time, I will send around an email to all of you with a proposed agenda for the meeting. I don't notice that as a public meeting. Why?
There's a chat, allows not common.
No, because one of the requirements around emails, if all you're doing is sending, communicating about what to bring up at an upcoming meeting, those emails are not subject to public disclosure. So I can send a draft around and say, I think we ought to discuss the following 10 items at the board meeting. Does anybody have anything to add? We're not discussing the substance of those items. We're discussing what to discuss at a meeting. But we'd never get anything done, and we'd be in perpetual meetings if every time that I had to send an email asking what do you all want on the agenda, we had to notice a public meeting about that conversation.
That's why I never reply all.
Right,
Fine.
it's best to do one-on-one. It's also why I tend to interact with all of you one-on-one on those issues, because it would just get unwieldy, obviously, to attempt to notice a public meeting just because I want to know if, you know, is this an item with, you know, what should we discuss? Can everybody tell me what we should be discussing at the board meeting? So, but electronic communications that deal with scheduling, that deal with, you know, topics to be raised for discussion, that deal with, timing, those kinds of things are not considered public meetings with the statute. Now, there are times, obviously, where there are going to be things that a board needs to talk about that it really shouldn't discuss in public. And that's where things can get complicated in these statutes. So, the statute itself gives you several, I'm gonna talk about two things, actually. There are two ways by which a board can do things, quote unquote, secretly or non-publicly. One is to have votes by secret ballot, which is something we've never done, and I can't imagine we'd ever do, except in a rare circumstance of whether we decided we wanted to elect board leadership if there was a contentious thing about who's going to be the treasurer or who's going to be the president. You can do secret ballots that way. And that's basically to enable everybody to get out of the middle school realm and back into college so that they can deal with each other moving forward and not, you know, carry tremendous amount of hard feelings. And to vote to elect members of a search committee. But we do all that in public too, and I actually recommend that all those things be done in public because I think it's important for the public to know how people vote on things and why they vote the way they do, and for people to be able to explain their votes and explain their positions. Now, the statute gives us as a board, gives all boards of local bodies several bases for going into an executive session. An executive session, as you know, is a session where we go and we meet privately. Those executive sessions have to be recorded, and those recordings need to be maintained for 90 days. With one exception, and that is with respect to the obtaining of legal advice on specific issues. So these involve property transactions, attorney conferences. Now, I know I'm an attorney, but I'm not included in the analysis here when it comes to attorney-client privilege or seeking legal advice. I mean, I may sometimes sound like I'm giving legal advice, but I'm not. Just because I'm a lawyer and I tend to talk that way, but I'm not the district's attorney, and I never can be the district's attorney. So we have an attorney for the district, and that is our outside counsel, Ashley. We can talk about laws, rules, and we can talk about certain things where the laws or rules or regulations mandate confidentiality, and I'll go over what some of those are next. Security and investigations, negotiations, personnel matters, and documents protected under CORA. So if we're going to discuss something that is the subject of a document that would be protected under Cora, it's something that we ought to also discuss in executive session, because we can't make public the contents of a privileged document by virtue of having to conduct a public meeting about it. So the statute recognizes that there are circumstances under which we're going to have to discuss things, obviously, that are confidential in nature. And let's keep looking at it.
So how would you say that we're going into executive session for that? Just say we're going into executive session to discuss documents that are protected.
We'll talk about how we go into executive session, because it's interesting. The courts are very strict in their construction of the statute. And the way in which an executive session needs to be announced and justified, it needs to be very specific. It needs to cite the specific statutory reference. So let's say we decide we really need to seek counsel from the district's attorney on a specific legal subject matter, pursuant to section 4024B of the Colorado Revised Statutes, CRS. Well, what we would say is we would have to say that we're going into that conference to discuss with seek legal advice from counsel on a specific topic, and we'd have to identify the specific topic. All right, we can't just say we're seeking legal advice, bye. No, we have to say what we're seeking legal advice on, and the statutory provision that enables us to do that. And then it has to be, a motion has to be made to do that in exactly the way I just described. Has to be voted in favor of by 2/3 majority of the board. And then we can conduct an executive session consistent with the rules, and the rules require that we go into executive session. We then discuss only that subject. We can't then, and you know how it goes, sometimes you're talking about one thing and that leads somebody inevitably to say, well, there's this other thing this kind of relates to. Can we do that?
No.
No. And so
So.
we have to limit ourselves to the specific basis for what the authorization is. So again, going back to the example of our attorney conference, let's say we have gone into executive session to seek legal advice concerning a particular employment contract. Now, and we would say actually we'd have to say whose employment contract that is. We
Right.
can't say an employment contract. We actually have to say the name. And in fact, we've done that in the past where we have said we are going into executive session to discuss negotiations with a particular person concerning a separation agreement, for example, to get legal advice concerning. And technically, something like that could also fall into the category of negotiations, contractual negotiations. And I'll get to that in a minute, but whatever it is we're discussing, we have to limit ourselves to that. You can't go into the meeting and say, okay, well, employee so-and-so's contract, okay, let's get the advice on that. Well, while we're here, lawyer, can you also give us advice on this other employee? Because, we might need a contract with them. It's like, no, we can't. We can't. And the reason for that, is the statutory is very clear. You have to actually limit the executive session to the precise subject that you have identified in open session that you use to justify going into executive session. Only talk about that. Now, while you're there too, getting back to attorney conferences for a minute, those sessions do not need to be recorded. So as you have noticed, when we have an executive session where our attorney is giving us legal advice, she will restate the statutory basis that supports our going into executive session. She will state that the purpose is to give legal advice on such and such. And then she will say, we can now stop recording, because you're not obligated to record legal advice from counsel in those meetings. And then we go back to a recording and she will say, we just discussed getting legal advice on this specific topic. And we are now adjourning the executive session and going into public session. Any decisions that need to be made in an executive session, those decisions, those cannot be made in executive session. So I just misspoke. Any decisions that need to be made as a consequence of whatever is being discussed in executive session, those decisions need to be both discussed and decided in an open meeting in front of the public. Now, this can get a little worrisome when you're dealing with things like personnel matters. So let's switch to that for a second. So personnel matters, if we as a board have to go into executive session to discuss a personnel matter, Colorado law requires us to identify who we're going to be discussing, the basic subject matter we're going to be discussing without disclosing or getting so, you can't disclose too much, because then it basically undermines the whole purpose of having an executive session. But you have to do it with sufficient specificity to give people an idea of what you're going to be discussing about that personnel matter. And before going into that executive session, you have to give that employee the opportunity to have that meeting in public. So if we're going to, sorry, Logan, let's say we have to go to, he's the only employee in the room, so I'm gonna, well, he's not this worthy, but do you mind if I pick on you for a second? This is just for illustration purposes only. Let's say we want to discuss a personnel matter involving Logan. And there's a specific reason we want to discuss that. Before we can go into executive session to discuss this personnel matter, we need to go to Logan and we need to say, we have, this issue has come to our attention. The board feels the need to discuss that. We would prefer to do it in executive session to protect your privacy. But you are, of course, welcome to and entitled to a public hearing on this instead of us going into executive session. If Logan were to say, I want it in public, want the whole thing out there discussed in public, then we have no choice but to discuss it in public and all of it. And that's okay, because it's about that person. If that person has not, let's say the person has not, they've said, executive session, please be my guest. Okay, so we discussed the matter in executive session, but again, we cannot make a decision in executive session. But it calls for a decision. When we come out of executive session, we have to make a decision and we have to discuss it without violating the privacy interests involved that caused us to go into executive session in the first place. So it can be quite tricky, right? And so all of us as board members have to be very cognizant of what it is we say in public, even though we're supposed to be discussing it in public, we also have to be careful with that because certain privacy rights, for example, in personnel records and other things, those are protected, those are private. And so we can't just come out and say, well, but in his personnel record, it says such and such. So therefore, I think we ought to do so-and-so. Well, we can't do that because we can't, again, be referencing documents protected under CORA, personnel records being one of them, in the context of making our decisions. So it is something that, it is a fine line and we're all intelligent people, so we have to be careful. And if you ever have a question about how to address something like that, or whether to what can be said and what can't be said, the district's lawyer is the best source for getting an answer to a question like that. Negotiations. Why would negotiations be considered something that you would want to have an executive session about? Well, if you're negotiating a contract with another entity or individual, obviously most organizations and entities and people have a strategy in negotiations. They know what their bottom line is. You don't necessarily want to just go communicate that to the other side of the negotiations, right? You don't want them to know that because then, well, like you might just get only your bottom line or less. And so negotiations are protected because of that. It wants to give the local bodies the flexibility to be able to engage in negotiations fully and fairly, and to promote their best interests and protect their best interests, including their bottom lines, when they're involved in negotiations, whether it's contract negotiations or any other kind of negotiation. So that's the reason that that exists. I think that others are pretty self-explanatory. Does anybody have any questions about this slide? All right. So I told you I would talk about some of the things that are mandatory non-disclosure. So there's some things that disclosure would just cause such a substantial injury to the public interest that, that, it would behoove us not to discuss them publicly. And so there is a test for that, and that is when the material is far right box, or that when the material is so candid or personal that public disclosure is likely to stifle honest and frank discussion. Now, I've looked high and low for case law on some of this, and really there was only one where some guy basically threw himself at the mercy of a sheriff and declared himself to be guilty, even though he probably shouldn't have, and he should have, he probably wasn't completely sober. And so then the question becomes whether you can discuss that or not. And it's like, well, you know, no, because actually it obviated the need to even take action because it was so out there. But there isn't a whole lot of case law on this subject, so it's one of those things where there probably isn't gonna be a whole lot that would fall into that category. So it's better to sort of look at what are the mandatory non-disclosure areas. Well, law enforcement investigations, okay? Sexual harassment complaints and investigations. That is the content of the complaint and the content of the investigation, not necessarily the fact of their occurrence. Remember to try to distinguish between what our duties of disclosure are and what they aren't. We do have an obligation to disclose what it is we're investigating. We don't have a duty to disclose. In fact, we have an affirmative duty not to disclose what is transpiring in the investigation, or what the actual content of the complaint is, or who the people are making them, and so forth. Security, building security, security of our personnel, investigation details, again, same thing as above. Physical and cyber assets of critical infrastructure, that's pretty obvious, right? We don't want people hacking well, we've had that, and we've taken steps to try to avoid having it happen again because it's disgusting. But those kinds of things are things that that are actual mandatory non-disclosure items, so they're not things we can discuss in a public board meeting. If we have to discuss them, we would need to go into an executive session to do so, and in fact, we could be held legally liable for discussing some of these things in public. Take the next one, medical concerns relative to an individual employee or board member or staff member or member of the public. Same thing with mental health. Achievement data, home addresses, email addresses, phone numbers, personnel files, letters of reference. We get a bunch of letters of reference, for example, on various people who are applying to be the permanent chief. Those are not disclosable. Applications, or applicants for any employment position. There's a bit of an exception related to like a CEO level position, like a chief level position. And so there's going to be some material that would be disclosable on that, but again, not email and home address and those kinds of things. So again, those are the things that our lawyers gonna have to just tell us what to do. Or identification of specific landowners or parcels. So test scores, examination data, licensing examinations. We have a lot of licensing data and examinations that take place obviously in the district because we have a lot of firefighters who have to get them. But we, you know, talking about exam results or data or things like that in the context For example, I could see it coming up in conjunction with a fire chief position or even an ops chief position when we're talking about particular licenses. Well, how did they score on that? Well, that's not something we can talk about, at least not publicly. We'd have to go into, if it really becomes a matter of something, a matter that we need to know about, we'd have to go into executive session to discuss the details of those things. So I, as promised, told you that I would discuss, what is it that's mandatory non-disclosure, and that's one of them. Okay. So what is the process? Here, first of all, we plan meetings with 3 or more people, except for social gatherings, chance gatherings, or me calling one of you and asking, is there anything you want on the agenda? Everything else we plan. And we create an agenda, okay? And in that agenda, we're gonna include executive session information, just of the type that I told you. Then we have to, by law, post the notice and the agenda on the website 24 hours before the meeting. No less than 24 hours before the meeting. In certain, we have to. Then we conduct the meeting in accordance with the terms of OMA, which is the Open Meetings Act, and I'll go over that. And then we have to report the meeting in accordance with the terms. So that just gives you an overview of the process. Yeah.
So isn't there an exception for an emergency meeting? We have to have an emergency meeting as far as that posting for 24 hours.
There can be an exception in certain circumstances, but they're pretty onerous. Yeah. So I'm going to give you some hypotheticals now. You get to have some fun. All right, the first one. 3 out of 5 board members want to terminate a district manager's employment. They are concerned that the other 2 board members won't agree, and they want to keep it quiet given certain political matters that have come up. Is there a way that the 3 board members can discuss this matter and take action without implicating the open meetings law? Is there a way for them to do that?
Or we can discuss it in executive session, right? As I said, if we only need 3 to vote. 3 votes would against 2,
But that would have to be.
but that would be an open meeting.
Right, so is there a way to avoid noticing a meeting and having a public meeting on the subject?
Ryan's gotta see it though.
Oh,
We know we have like.
I don't necessarily have an answer for you, but I was muted and I was gonna say, couldn't they just discuss it individually and but no, I don't think that they could without posting a meeting if there's 3 that want to get together at one time, right?
okay, so we have people can discuss it one-on-one, but can't discuss it outside of, they can't
Meet together
meet together to discuss it
without notifying, right?
without a notice of the meeting.
Yeah.
All right, so let's talk about this. So the answer is no.
Okay.
Even if only 2 board members talk and agree amongst the 2 of them
Okay.
to move to terminate. All right, they have decided on an official action. That is not something they can do. They can talk about it. They can talk about how they're leaning. They can talk about what they feel. The 2 together can talk about it, especially if they're in a subcommittee, because they're gonna say it all in public. But at the end of the day, no formal action can be taken by the board without a public meeting. And so it is, while board members, 2 members can talk about matters of pending public decision, because they can't make a decision, right?
Right.
2 members can't then go say, I'm gonna get the 3rd member and we're gonna, so you have to be very careful here. When I, for example, reach out to you guys to talk about what do we want on the agenda, you'll tell me what you want on the agenda. And often I'll hear and we'll talk about what you think about the thing that's gonna be on the agenda. I don't hear anybody telling me how they're gonna vote. But I do understand when I've canvassed everybody about what's going to be on the agenda, that they want certain things on the agenda. I fully expect each and every one of you to overtly state what you think in a public board meeting. And then all of us can discuss it together, because there's no substitute for a full and fulsome discussion about these issues, because if you two are having a discussion about something, you two may think you sound great and it sounds wonderful, but I can sit over here and go, what the heck are they thinking? Well, have you guys thought about this, or have you thought about that? And you haven't had the benefit of that input yet, right?
Right.
And so while the two of you may have discussed it, you certainly haven't reached a decision. You may have reached, if you're a subcommittee member, a decision on what to recommend and why you're recommending it. But there's no substitute for the full discussion, and the full discussion in public, because it's the public that needs to hear, why is it that you're recommending that? Why, what does the rest of the board think of that? Why do they think that, right? And then for them to watch us go through that deliberative process and decide to what we think. Now, not everything involves a lot of disagreement about stuff, so we don't always have. It's not like each one of us needs to go through and repeat the other person. I mean, if we all happen to agree on a matter and it's a pretty simple matter, it's not gonna have a huge amount of discussion, but we have had things where it's not so simple, and we've had full discussions about it, and those are important discussions to have publicly. So the answer is no.
I apologize, Sandy. That take action, I missed that when I read through it the first time and was listening to you. So, but so we can discuss it. Just the take action is the thing that is obviously not able to be done outside of the public, correct?
Right, you can't have you can't take formal action outside the context of a formal meeting unless the subject matter you can't take action outside of a public meeting, period.
Yeah.
More than two board members can't discuss the subject matter outside of a public meeting unless for some reason the subject is one that justifies going into an executive session, as we've discussed what those are. Does that make sense to everybody? Any questions? You have a question?
Can I ask a question?
Of course you can.
How do you define in the course of outside of formal meetings, we call daisy chain? Because that's not permitted by the open meeting law.
What do you mean by daisy chain communication?
Daisy chain communication is when when all the members of the board or three or more members of the board all have conversations individually as if even though they're not in the presence of the other members.
So like what you're asking, if I'm understanding you right, is like, if I talk to Sandy about my feelings on a subject and then I call Scott and then I call Jeff and then I call.
Exactly.
Okay.
And then Sandy calls Scott and Scott then calls Jeff. And then all of a sudden, everyone has basically talked about it, skirting the confines of open meeting laws.
So what I think is that most of the conversations, to the extent we're having conversations that are daisy chain conversations, if you will, although they're not really, because if I'm going to everybody and saying, what do you want on the agenda? I'm not going to the next person saying, so-and-so says these should be on the agenda. Can you tell me what you want on the agenda?
That's not right. That's not a
Right.
daisy chain. But with Colorado the Freedom of Information Coalition has a whole chapter on this.
Right,
Because it is a problem, especially with small boards.
yeah. So I think that the subject matter of this hypothetical actually goes right to that. So the answer is no, you can't. The two of you can't talk and decide how you're gonna do it and then go call the third person and decide how you're gonna do it and then come in and purport to have a public discussion about it. The only discussion that you should be having substantively about substantive matters is if you're on a subcommittee and there are two of you, and those two people are gonna make a recommendation to the board, the full board, about what they think the full board ought to do, and the full board is gonna have a full discussion about that. And usually well, you'll see that actually happen today. So there are two committees that I actually consolidated into one committee. One is and I was going to announce this later in the full board meeting, but I'll tell you anyway. Which doesn't really require, it just requires me as the president to appoint people to subcommittees. We don't necessarily have to do it as a board. But I consolidated the two because it didn't make a lot of sense since the efforts were duplicative. One involved looking at what fire prevention is doing in the context of wanting grant funding, spending, and the other is restructuring. Because those two ended up basically just merging into one. It didn't make sense to take up all the staff time and having all these separate meetings about the same subject. And so we had one big giant meeting and got to a resolution where I'm going to be presenting the recommendation of that single subcommittee. And so I'll present that recommendation. The only two board members that have been involved in that process, well, there were three, because there were two subcommittees. There was one that involved Ryan and Jeff, and there was a separate subcommittee that involved me and Ryan. And I knew that they were meeting, and I knew that we had to wait on the results of some meeting they were having, which I didn't know was the substance of. All I knew is they're in too many meetings, and it sounds like everybody's doing the same thing. So I'm going to consolidate the committees. Now I've got to consolidate it to two people, because now it's going to be one committee instead of two committees. I want two people on it. I need one from the other committee and one from the restructuring committee. So now the committee is me and Ryan. And then we had to have a separate meeting to figure out what the universe of issues was, because we're not having the Daisy chain conversations. We had to figure out the universe of issues and then we had a 4.5 hour meeting. I think we had a 4.5 hour meeting. We had a 4.5, and we really got a lot done. And now this subcommittee of these two board members has a recommendation to the full committee. And I have slides for that too, so everybody will see that. Yeah, you're right. You don't go one, then to another, and try and then everybody just comes and announces the decision. You have to have a discussion about it on record. Yeah.
Just a question on that. I don't think it's daisy chaining, but like us as a board. I mean, Ryan's a firefighter, so he might know, but like I've reached out to Scott because he was a chief before, because there was something I didn't understand. And if I reach out to him and everybody else reaches out to him, but none of us talk to each other.
Well, so reaching out for information is also fine. So I can communicate information to you. I can send you articles. I can send you information, and none of that is, you don't have to notice a public meeting for that.
Okay.
The issue is whether you're taking a matter of substance, pending issue before the board, an issue that the board has to make a decision about, and you're deciding together how it is you're going to act on that particular issue
In the open meeting.
separate from the open meeting. So you're doing it in all these conversations outside of a public meeting, right? And then just coming and announcing the decision and not, having a full and fair discussion about it in public, right? The normal conversations that we have and that I've had with Scott too, because I call him, what's that? Especially being new to fire departments, right? That seeking to just get information, hey, does this fall in the land of the fire department, or does this fall in the land of the town? Those kinds of communications, you don't have to notice a public meeting for those. They fall in the category of documents and other information that can be communicated between board members that don't have to be subject to, and now that they may be subject to, the documents themselves, the emails themselves may need to be produced under Cora, and all of that's fine. Like if, I send all of you an article on such and such, and Patty goes and asks for any communications about between board members about such and such, and that happens to be responsive to it, she can see the email.
Right.
But we don't have to notice a public meeting around the fact that I sent that article to you.
Okay,
Okay, all right. Hypothetical number 2, same scenario as before. But 3 of the 5 board members who wanted to terminate the district manager decided that they would raise the issue at a public meeting when discussing new business. Is that sufficient notice under the open meetings law, and can formal action be taken based on that notice?
Has to be on the agenda.
Yeah, you,
Right,
you bring it up in, new business.
Yeah.
But then it has to go to the next meeting.
right. Under the OML, notice requires a specific agenda information where possible. Now, sometimes, what I try to do to keep the agenda shorter than, I would just to try to keep it to a page, is I will try to, give a description of it that gives everybody notice of what's going to be discussed, but it may not be the specific details as it ultimately end up being set forth in the motion, if that makes sense. So today, for an example, we're going to discuss discussion and action, risk reduction division, name and structure. So structure implies there's something to do with the organizational structure we're going to be discussing, and that action may be required on that. But I didn't get into the details of my slides yet or anything like that on there. So notice just needs to give people sufficient idea of what you're going to be discussing in more detail at the meeting. Now, what would happen if we took action? Let's say we didn't know that we couldn't do this in the context of new business, and we took action anyway. What's the consequence of that?
Probably null and void or actions.
Right, so any formal action taken related to that issue is void. Now, that could be a problem when you've terminated somebody, because now you have to reinstate them. Right?
Well, do you? Because they weren't really terminated.
They weren't really terminated. I mean, and you have to pay them for the time that they weren't doing their work. And oh, by the way, and this happens in some of the case law where school boards terminate a teacher and they screw it up somewhere along the way, right? They do it in executive session. They make the decision in executive session, terminate the person, send the notice, say bye-bye, adios. And then they engage in litigation about it for the next 2 years. And this teacher, guess what? 2 years later, court comes along, says void. Not only do you give him his job back, you got to pay him for the last 2 years. Oh, and you get to pay his attorney's fees too. So it's really a good idea to avoid having things voided if you can. Really a good idea. All right. So now a third hypothetical. A board properly entered an executive session to discuss contract negotiations. During the executive session, the board decided that it would not pursue further negotiations because of dissatisfaction with the terms provided. Does the board need to do anything further regarding the contract negotiations after the executive session?
Yes, yeah,
What does it need to do?
I would say you have to come out and say, make a motion that we're no longer going to proceed with whatever we're doing.
Right. So it's okay to say in public that you're not satisfied with something. You don't have to get into the specific details of the negotiation to say you're not satisfied with something. You can say to a point why you're dissatisfied without revealing negotiation strategy and things like that. But again, any action that you're going to take any board action has to be taken in public. Even if the discussion about it has to occur in executive session, no action can be taken during the executive session. That can only be taken during public session. Again, this can become pretty tricky, right? Because you start having these attorney-client privilege conversations in executive session, and you have to come out and take action on something that was discussed and that you just sought legal counsel about, but you really can't say anything about what the lawyer just told you, or you've now violated the attorney-client privilege and potentially actually made discoverable all the communications with the attorney on that subject because you've just announced in public what they said. So again, have to proceed with great caution when coming out to discuss or take action on things that were discussed in executive session, because you don't want to basically nullify the entire purpose for which you went into executive session by coming out and trying to make a decision and then revealing everything that was discussed, because then you can run afoul of other laws too, whether they're privacy laws or, you know, voiding attorney-client privileges and things like that. But if formal action is taken in an executive session, it's going to negate the privilege associated with the session. And so all the privileges associated with the executive session are going to become public. So if we were to attempt to make the decision in executive session and then not come out and make the decision in an open session, then we have voided the privilege associated with the executive session, and then the recording becomes public. Okay. So, and again, it's more than just coming out and doing a motion. We have to exit the executive session. We have to open the topic up for discussion. Again, the discussion has to be carefully navigated because we can't disclose certain things. And then a vote and a motion and a vote would be taken with respect to discontinuing contract negotiations. This is a simple hypothetical, but if you translate that into, we've gone into executive session on, you know, seeking legal advice about something, or into a personnel matter involving an employee, and now we have to come out and make a decision on that. Again, some of these conversations, some of these public discussions have to be very carefully navigated. Okay, last one. A large wildfire starts and requires the dispatch of a significant amount of district personnel. I didn't think I was gonna be able to talk to you guys for an hour and a half. I'm gonna be able to do it. Significant amount of district personnel requires the chief's full attention and demands district funds be spent immediately. Can the board call a meeting outside of the 24-hour notice requirement?
Yes, you can do an emergency meeting. Best process, policy then after that at the next meeting, explain why you did it, what it was.
Right, okay, exactly. So there are some emergency meetings that can occur outside of that 24-hour notice window, where it would be quote impractical or impossible. This is one of those circumstances where it likely would be considered impractical or impossible. And as Scott pointed out, the best practice is to, at the next meeting, or as soon thereafter as practicable, call a special meeting to validate, ratify what was done in that meeting in public. Okay. All right, there's my hypotheticals. So we've talked, here's the, you know, basically the meeting roadmap. We follow all these things, agenda items, reports, presentations, participants, time allotments. You have to identify supporting materials, which we do in our board books. Have to identify resolutions. We need to be specific about motions. Offer public comment, give guidelines and time allotments with respect to that. And, you know, comply with the statutes. So for example, if we have to go into executive session. Notice has to include the date, the time, the location, and the agenda. We've talked about that. All right. Here we open the public meeting, we conduct the discussion, we allow public comment, we vote. If we have to go into executive session, we do what we were talking about before, which is identify the statutory provision authorizing the executive session. We have to describe the matter to be discussed with sufficient particularity. I'll get to that in a minute. We have to vote to adjourn the session and to convene the executive session. Again, that requires 3/5 majority vote. We have to record the executive session, except that we don't record legal advice given. And then we have to post the minutes of the open meeting, and we have to maintain the records of the executive session for 90 days. All right, let's see, gotten through most of this already. I've put some rules of order in here in case anybody's curious about them. Because we don't really follow this, and I've been thinking maybe it would be a good idea to start doing it. The member making the motion states the name and recites the motion. The seconding member states the name and seconds the motion. The president restates the motion. See, I mean, it would take us 10 minutes to get through this. Restates the motion and invites further discussion. President declares an end to the discussion. Can you imagine if I just declared, okay, you're all done, and initiates a vote? The secretary records each member's vote and announces the vote totals on the record. And then the president states whether the motion passed or failed. This is a very traditionalist view of it. It's why you sometimes hear me though restating a motion. Like someone will make a motion or I'll say, I would like to hear the following motion. And then someone will make that motion and say what she said. That's fine because it's recorded. But then sometimes I'll restate it again. And then we'll get a second. We tend to discuss these things beforehand, but I'll say, is there any further discussion on it? And no further discussion on it, then I'll end the discussion and ask for a vote. And then I always say motion carried, I'll announce what the vote is usually. Well, always. I don't think I've forgotten that yet. Scott would kick me if I did. Not hard. All right, executive sessions. We have to have a motion and a second citing the specific statutory authorization. We have 2/3 aye. We have to, then when we record the meeting, recite the statutory authorization again at the beginning of the executive session itself. And then, as we've talked about, can discuss only matters identified in the motion for closure and nothing else. I gave you some sample statutory citations. So example 1, agenda item 1A, discussion related to staff personnel evaluation. This portion of the meeting will be closed pursuant to Colorado Revised Code, This could be, in this case, a general personnel evaluation. And that for whatever reason needs, or it's a specific evaluation to a person, it would need to have the specific person's name. And again, they'd have to be consulted with whether they wanted it open or not. Agenda item, example 2, discussion with counsel regarding legal advice specific to pending litigation. So that's the specific topic, is the pending litigation. It could be something else, but let's say that there's some kind of litigation we're involved in and we're going to discuss the pending litigation. And then we say it's closed pursuant to the statutory authorization for that type of closure. All right, it's best according to the statute to have recordings of both audio and video and make them available for public inspection. We also should have detailed written minutes, review with me before further distribution. Always label them draft before, distribution. Published to the website promptly before the next meeting, make available for public inspection, and they have to be kept by the board secretary. Any questions about this?
Do have one. Can a board member attend an executive session via Zoom or other?
Yes.
They could potentially record that meeting.
If they recorded it separately on their phone. But the meetings should be recorded.
No, I mean, that probably wouldn't be ethical for that other person to record it.
It wouldn't, but it's gonna be recorded by Zoom, and the Zoom will announce that it's being recorded, and as you know, like the few times we've had executive session, we have announced that it's being recorded at the beginning, and then announced when the recording is ceasing. And then we've also announced when we're stopping recording on the formal recording. And the basis for stopping the recording, that it's, that because we're obtaining legal advice. If someone materialized with a recording of that meeting that was not supposed to be recorded, yeah, I'd say they'd be in a fair amount of trouble. I mean, it's like mishandling attorney-client privilege information of the board. It's one of the most serious bad things you can do. Any other questions about? Are you good? Yes, ma'am.
Just curious, if a board member were to violate the trust of other board members, which I think is basically what you were asking about, the board cannot, I guess you could censure that person, but you can't do anything about it because that person has been elected.
Correct.
Just curious.
But we can publicly censure the board member. And the public can decide what they want to do with that information. And there could be recall votes, there can be any kind of vote of no confidence or any number of
But as a
things.
board, an elected board doesn't have any power to screw.
That's correct. That is correct. We really only have the power to censure each other. You know, maybe we're all elected, the people elected us, so there's not a lot of recourse there, but at the end of the day, we can also make decisions related to that person's exposure to certain type of information. Because of past incidents like that. You know, I think exposing anybody to attorney-client privilege information who has conducted themselves in such a way as to show themselves willing to just willy-nilly publicize that information or make it exposed to disclosure when the district has a very serious interest in protecting that type of confidentiality, would be a reason to, as a board, act to ensure that that particular board member doesn't have access to that particular type of information. All right. Contents of the minutes. When I do the minutes lately, which hopefully I won't be doing for long. Right, we're hiring somebody. And when we do the minutes, I try to remember to put in the header, that they're in draft format until they're final. And that is, there's just a practical reason for that, and that is that, you know, the first draft might have missed a whole section or might have, gotten something wrong, and you go back and look at the video and it's like, oh, that's wrong, so you fix it. See, that's the reason drafts occur. But if you don't have it labeled as a draft, then somebody comes along and says they want to you to produce everything related to the minutes, and there's just a whole bunch of different what looks to them like a bunch of different versions of the same minutes without anybody having labeled them drafts. And they're like, well, why did somebody think that was in the minutes? And if it's labeled draft, you can see that was, so it's just a good idea, from a practical perspective, to make sure that when it's still in draft form, it's labeled that way. It has to include the date, the time, and the location, who was present and absent, describe all the matters considered. I'm gonna take an aside here because minutes, they don't have to be a transcript of video. So it is okay to have, this was considered and this is how they voted, and to summarize it briefly. It's hard sometimes to summarize some things briefly because there's important discussion that occurs, and I've been trying to include those discussions in the minutes where possible. But really, because we're publishing also the video and people can go back and look at it and watch the whole meeting if they want to, it doesn't have to be a transcript of the meeting. It needs to include the motions, the resolutions, the amendments, the materials considered, the record of the votes taken, and whether an executive session occurred. So with a brief description of the topic and the citation and statutory authorization, as well as a record of the vote to go into closure. Any questions about this? All right, meeting cancellation. All right, has to be done 2 days in advance. Has to modify the published notice to state canceled and the published calendar to state canceled. And I just have Miranda does this like canceled across diagonally. Is that, oh, you do that?
No, can you cancel for weather? There's severe weather, say, meeting's gotta be canceled. You don't have the 2 days notice to do that.
Well, I think we could just conduct the meeting by Zoom. So we could probably amend the notice to declare that it's being conducted by Zoom
If you have that.
yeah, if you have that available to you. But obviously, again, you can have situations where it falls into these emergency categories where you don't.
I'm sure they're having those back east right now.
Yeah, you are, or your entire board is stuck in New York where there's now, according to my daughter, like 26 inches of snow on the ground and nobody can get anywhere. Things do happen rarely, and those things are, the statute does make allowances for those kinds of situations. Emergency meetings, okay, you have to issue the public notice immediately, as soon as you can. You have to explain the meeting's purpose as soon as you open it and what the nature of the emergency is and how notice was provided. So even if notice was only provided 2 hours ahead of time, you need to say how it was that you provided notice, what you attempted to do to give people notice of that meeting. If it has to be closed, you have to cite this, you have to do the same thing as in any other meeting. Then you reopen and take official action if necessary, you adjourn the meeting, and then you report it as a normally noticed meeting. And as Scott pointed out again earlier, it's just that it's a good idea to refer back to it in your next meeting. All right. The statutory framework for the Open Records Act is really not that much different. It just doesn't relate to meetings. So basically, all public records should be open for inspection by any person at reasonable times. So custodian rules, any rules that we have or develop around inspection have to be reasonably necessary for the protection of the records and to prevent unnecessary interference with the custodian's duties. So if somebody comes in and wants, 8,000 pages of documents, all right, that might take a little time. And so we might have rules around that, around the amount of time it's going to take. And, communication is the key. But obviously the custodian's duties are also important. And so our rules have to factor that in. We can't demand the identity of the requester unless the record is confidential. Like relating to personnel or something like that. So you have to ensure public access to the records without unreasonable delay or costs, according to the statute. So within 3 business days, we should provide the information that's requested. Now, if the records that are being requested are actively in use or not readily available, I've seen situations where the records being asked are so old they're on microfiche somewhere. So that's not something that's going to be accessible within 3 days. Someone would probably have to go dig up a machine to even figure out how to look at them. So, if something's not readily available for whatever reason, it's in storage or whatever, then, there are provisions for delays around the 3 days. If the request is overly broad, some can be, or it's a period of very high demand. I think, Patty, we had a request from you come in right around the time we lost a bunch of employees administratively. And it wasn't like you were making an unreasonable request. It came in at a time when there's nobody here to respond to it. So you work with people. I think we worked with you, and then you get it done. But you can extend it beyond the 3 days when it is impossible for some reason, like it was in our situation a few months ago. So you have to notify the requester of the delay in writing and set a reasonable time. As again, communication. But it can't really exceed 7 working days unless there's some really exigent circumstance. And you have to provide the records in the same format in which they are stored. Any questions around this? Again, these are the same things we went over below earlier when we talked about OMA, but these are the grounds for denial of inspection. And the reason why I'm repeating them here is again, because it relates also to documents. And as I mentioned earlier, we can't be discussing the content or privacy interests of somebody in the context of a meeting when the documentation around that thing is confidential, especially if the subject that is covered in the confidential documentation would be the subject being discussed. But again, this is one thing that's different in the deliberative process documents where the material is so candid or personal, the public disclosure is likely to stifle honest and frank discussion. We would be obligated to swear out a statement describing the document, why it's privileged, why disclosure would cause injury to the public interest. So if there's something like that we are going to withhold on that basis, that is something that we need to do. And by swearing out, that is a document you have to sign under oath, under penalty of perjury. I didn't go too much into Cora because we as a board don't really get too involved in that process. It's more the administrative staff that has to handle those requests. But I wanted to cover it sort of generally so that you had an idea of you know, what the sort of practical and normal, what the basic statutory provisions were around it, that we're dealing with, that the staff deals with. Okay, that's it. Any questions?
I think I have one on, work sessions. So don't make decisions on work sessions. That still has to be publicized because we have more than 3 people. Do we have to take public comment? Can we limit that there's no public comment?
We don't have to take public comment in a study session or in a work session. Because we're not making any decisions, or we're discussing an issue of, well, like today. Okay. I'm gonna leave, oh no, I'm not gonna leave the meeting. Because I have a slide to leave.
We actually have a separate meeting link for the next meeting,
So-
but I'll send it.
So yeah, I mean, study sessions and work sessions are sessions where they're kind of learning sessions, right? And so there's no need for public comment in those sessions, but a public meeting discussing the public's business where there's the opportunity to make a decision on the issues under discussion, then those meetings need to have an opportunity for the public to comment.
But we obviously let the public.
We let the public comment more frequently. I mean, I think this board, what I like about our board is that we're very focused on maintaining open meetings and being very open and including the public in conversation about issues of importance. I mean, obviously, we can't include open comment on every single issue or we'd never go home. We'd be in perpetual board meeting, but I think just exercising some discernment around the room and when people are feeling like they would like to participate in the conversation, in the discussion, and being aware of that and then enabling it is a good thing. And I think we've all done that, so. Any questions from anybody? Logan wants to know what we discussed about him in executive session.
Right.
All right,
All right, thank you, good job, and,
Yeah, thank you.
good refresher and some new information as well, thank you.
Thank you, Sandy.
you're welcome. I'm gonna leave this meeting and join the next one. Miranda, would you send me the link to that one too at some point? Cause I'll,